of his office, in which the president is no longer in charge of execution. Now the president will be in charge of the judicial function of deciding whether or not every provision of the GAA is constitutional. So is the president the head of the judiciary, or is he in charge of executing? Now, there are, as Representative Tino stated earlier, certain areas in which the president can exercise his veto right, but I maintain, and I think that my fellow colleagues here should consider, that this is always the exception in the role of the president, and that the veto power is not the primary function of his office.
That's the meaning of prerogative, to veto or not to veto. Now we proceed to the Honorable Vice Chair Dumogan.
Thank you.
Our last speaker on third offense.
Thank you, Madam Chair. In addition to what had already been said, which I fully agree, let me point out that the budget, which the President failed to veto, was passed by both houses of Congress. Why should we fault the President if he did not exercise his discretionary power to veto what had been passed by both houses of Congress? On that score alone, I do not think that it can be considered as illegal violation, which is tantamount to culpable or willful violation of the Constitution on the ground of betrayal of public trust or corruption.
That ends our discussion on the third offense. The committee acknowledges all the significant comments and opinions on whether or not there is a recital of facts that constitute an offense determinative of the jurisdiction of the Justice Committee. Let us all be reminded by our parameter that we need to establish the offense to the ground of impeachment under which the same is anchored. Now we are moving to our fourth offense. Please allow the chair to read. Respondent benefited from kickbacks arising from budget insertions and ghost flood control projects. At this juncture, the chair elicits the comment, opinion, and reaction of the committee members.
Madam Chair.
Mag-walk out ka uli.
Hindi na.
The Honorable Abante is recognized.
Usapan ngayon eh. Kaya kasama na rin ako dito. But anyway, ito pong fourth allegation. Isa lang sabihin ko dito. Nakalagay po sa ating rules, if it finds that sufficient grounds for impeachment do not exist, the committee shall dismiss the complaint and submit the report required hereunder. Ito po, it does not actually exist because everything that is said here is hearsay. Yun lang po.
Thank you. The Honorable Rodriguez.
Madam Chair, in this fourth act, which is alleged, it is clearly based on the fourth ground of impeachment, which is graft and corruption. The Supreme Court, in the case of Francisco versus House of Representatives, clearly already said that this is defined under the Republic Act 3019, which is the anti-graft code, the anti-graft law, which provides Section 3B and C. These are the main, if this is an allegation of a public official who receives kickbacks and from ghost projects and so forth, it should be under this. And it is clear, Madam Chair. We have to therefore go whether there's a recital of facts in relation to, Madam Chair, Section 3B and C. And here we go. This is now what it says, Madam Chair. It says Section 3A, knowingly, deliberately, requesting and receiving money because of an important project or permit to be issued by the person. There is no allegation here, Madam Chair, that the President requested, that the President received money because he has a permit or contract to give. That is precisely what is stated here under under Section 3A. Directly or indirectly requesting or receiving any gift, present, share, percentage, or benefit for himself or for any other person in connection with any transaction or contract between the government and that party. The second one, 3C, also is directly or indirectly requesting or receiving any gift and so forth for himself and another in a manner or capacity that has secured or obtained this particular permit. So there are only two. There are only two provisions under Republic Act 3019, wherein, according to the Supreme Court, the fourth ground could be anchored upon, and there is no allegation here. Now, there is a statement here about Ako Bicol party list. This is a narration of fact, the recital of fact. However, the problem with this fact is that it was delivered to respondents' allies. If you can look at this, not to the President. Now, this is an impeachment, proposed impeachment of the President. And then attached copies of the video expose. Madam Chair, the video expose is abroad, wherein we, in the later part, will have to hear this particular person has to be present. Otherwise, it's a piece of paper and a piece of video that is not allowed to be introduced in any proceeding. Because we have to give the chance to the respondent to question always. This is the cross-examination. This is the time to also provide the respondent the time to question, cross-examine the person who said that the money was given and he is not in this country. He's either in Portugal or Sweden. And so therefore, Madam Chair, once again, the fourth ground, which is respondent engaged in graft and corruption through kickbacks and ghost projects, there is no recital of facts that will constitute the violation of Republic Act 3019. Thank you, Madam Chair.
Madam Chair.
That is a significant discussion on graft and corruption. And of course, we recognize also the needed authenticity about the video of this expose. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Yes, on allegation number 4, respondent engaged in graft in corruption through kickbacks and ghost projects. The allegations which seem to justify the said charge are contained in paragraphs 27 up to 32. Reading all these paragraphs, they do not contain the narration of facts that will pinpoint to the President, that will somewhat allude an illegal violation which is tantamount to graft in corruption. What had been stated here are allegedly given to certain allies. It's too vague and too wide to consider. So, looking at all of these allegations, clearly it does not justify the ground, again, to impeach the President on graft in corruption under the provision of Article 10, Section 11 of the Constitution.
Thank you, Vice Chair Dumogan. Our last speakers for the fourth offense are the Honorable Acosta, the Honorable De Lima, and the Honorable Colliantes, one after the other. The Honorable Acosta is recognized.
Thank you, Madam Chair. This is just a reiteration of my two senior compañeros. Is the lack of the ultimate facts required for a charge of graft and corruption based on the 6 paragraphs of the number 4 allegation, Madam Chair. It mentions suitcases of cash and ghost flood control projects. But Madam Chair fails to provide 1, specific dates, 2, specific persons involved, 3, specific project names, And lastly, is the direct links to the President's personal involvement in this case. Madam Chair, it is my humble opinion that these are generalities and broad generalizations, which, according to the Supreme Court, in that case of Gutierrez versus House of Representatives, GR number 193459, are insufficient for impeachment, Madam Chair. Thank you.
Thank you, Honorable Acosta. Next is the Honorable De Lima.
Thank you, Madam Chair. As to this fourth ground, general ground, graft and corruption, and the main specific allegation that allegedly the President benefited from kickbacks arising from budget insertions and ghost flood control projects, with 4 sub-allegations. 1, Pbbm orchestrated insertion in GAA for kickbacks. I agree with the Honorable Acosta that it lacks specificity as to what, how, and when, making this a conclusion rather than a factual allegation. The nexus, again, between the factual allegations and the ground of graft and corruption was not established due to the lack of specificity of the allegations in how Pbbm orchestrated the flood control scam for kickbacks, other than by sweeping statements that are more of conclusions than allegations of specific acts. Sub-allegation number 2, suitcases of cash were delivered to Pbbm's political allies. Again, lacks specificity as to who, what, how, and when. Sub-allegation number 3, the ghost flood control projects confirm plunder of public funds that is not possible without Pbbm's approval. This is a conclusion rather than a factual allegation. The fourth and the last sub-allegation for this ground is Pbbm is allegedly the central figure in corruption schemes. This is again a conclusion rather than a factual allegation. In all of this, in light of the evidence uncovered, I just wonder, in light of the evidence uncovered in the multiple fora investigations conducted on the flood control scam, medyo kapos talaga sa allegation yung complaint. It seems overly complacent for the complainant to be sparing in his factual allegations as to establish the ground for impeachment. For me, Madam Chair, there is simply paucity of factual allegations. Again, this is insufficient.
Thank you, Honorable De Lima. Our last speaker on the fourth offense is the Honorable King Colliantes.
Madam Chair, I'd just like to manifest my support for all of the comments said by our dear colleagues. But really, the question right now here is, are these just conclusions made by the complainant, or are these really based on fact? Remember, we have to go back to the verification, which says that all of his allegations must be based on personal knowledge. Does the complainant have personal knowledge? Was he there when these alleged transactions happened? Does he have any basis based on authentic records to say that money was transferred, money was provided to the president? I doubt it. So I think based on what is written on the complaint, it is insufficient as a ground for impeachment. Thank you, Madam Speaker.
Thank you, Honorable Colliantes. That concludes our discussion on the fourth offense. Now we are moving to the fifth offense. Please allow the chair to read. Respondent created the ICI to shield corrupt allies. So this is the offense, and the same is anchored under any, some, or all of the following: graft and corruption, culpable violation of the Constitution, and betrayal of public trust. At this juncture, we elicit the comments and opinions of the committee members. First, we recognize the Honorable SDML Lawrence Defensor.
Thank you, Madam Chair. I would have to speak. I'm compelled to speak for the membership of the ICI regarding this allegation that it was created to shield corrupt allies. Madam Chairman, the appointment and participation of the members of the ICI, particularly Secretary Rogelio Singson, whose integrity and reputation speaks of good governance, contravenes the allegations by this impeachment complaint head-on. Hindi ka maglalagay ng mga taong naging ehemplo ng mabuting patakaran at pamahalaan kung ang balak ay pagtakpan ang korupsyon. So the membership itself of ICI, a presiding justice of the Court of Appeals, an SGV partner who is a partner on audit, and someone like Rogelio Singson, who is a model for good governance, clearly runs contravene against this allegation in the creation of the ICI. Thank you, Madam Chair.
Thank you, Honorable SDML Lawrence Defensor. The Honorable Franz Legaspi is recognized.
Thank you, Madam Chair. I'd just like to give a very short manifestation to take note of the evidence or the annexes presented, the evidence in the annexes presented. For me, and this is a general observation as well with the earlier topics, but in particular for this ground, there are a lot of evidences the sources are only media outlets, news sources, and I think this was generally already noted by our members of this committee. But in this particular ground, these articles are, I think, 4 opinion columns, mostly predicated on the opinions of certain personalities, certain characters. And I think in relation to the particular ground that the complaint wishes to state, I believe I think it's clear, the betrayal of public trust with regard to the creation, or rather the ICI's creation, somehow affecting or resulting in a loss of public trust, which would, in this case, be a ground to impeach the President. I think it's very clear on that part that the evidence presented is not directly related to that particular ground. And also, it's also vague with regard to the metrics or how it could match or say that there was a betrayal of public trust or that the trust ratings are affected by the creation of the ICI. So that's my humble submission, Madam Chair. For me, I think this is, just based on this ground is already insufficient in substance as well. So thank you, Madam Chair.
Thank you, Honorable Legaspi. We are on the last offense. This is the allegation that the creation of the ICI is used to shield the allies of the impeachable official. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. Again, it appears that this is one of an allegation that is not at all supported by narration of facts. In fact, as we all know, aside from what had already been stated, the integrity and competence of the members of the ICI appointed can disprove this fact. Second, they have investigated all those that had come to their attention related to corrupt implementation of projects, which clearly disprove the allegation that it has been created to shield certain allies in government. So it's far, far away from establishing a legal violation which is considered as willful violation of the Constitution as an impeachable offense. Your Honor, thank you, Madam Chair.
Thank you, Vice Chair Dumogan. Any other comment or manifestation from the members? The Honorable Po.
Madam Chair, the creation of an anti-corruption body in and of itself is not an impeachable offense. Now, there's an assumption in this grounds that it was used for shielding. However, what we actually have evidence of in terms of the ICI's actions is that its investigation included both allies and non-allies alike. Its recommendations also had both allies and non-allies alike. And if we're going to discuss further, I would caution our colleagues on finding substance in this because we do not want to discourage future anti-corruption efforts. We don't want to discourage future transparency efforts. What we're discussing is the willful violation of the Constitution. But what we have here on record is the willful act of the President for transparency and accountability. That's what we have objective fact on. So I just want to make sure that we are not dissuading efforts for transparency and accountability within our government by finding substance in this.
Madam Chair.
Thank you. The Honorable Rodriguez.
Madam Chair, I take exception to this particular ground for impeachment. I personally know a former Secretary of Public Works and Highways, Rogelio Babe Singson. I was already congressman of the 2nd District of Cagayan de Oro. And he often comes to Cagayan de Oro to be able to look at projects. And during his time, and even up to now, there are no ghost projects in Cagayan de Oro 2nd District, nor any substandard project. Now, he would not accepted if this is a shield. And he would not have continued until he, because of health reasons, has to therefore resign. But during the term that he was there, together with the SGV representative and former Presiding Justice Reyes, it was clear that they were able to invite and get documents. And some have already been recommended for filing. If this were a shield, then there would have been no action of the ICI. But there were many already given to the Ombudsman for investigation and preliminary investigation. So therefore, this is something that it does not give justice to those who have already been appointed and had worked on this particular ICI. And so therefore, I personally know the former secretary, and I was very happy that despite the fact that, he has been retired, he's retired, he took the job because he believed that the ICI can make a difference in stopping all of this flood control mess and then be able to send the proper cases and documents to the Ombudsman, which is the jurisdiction over cases of graft and corruption and plunder. Thank you very much, Madam Chair.
Thank you. Next is the Honorable Lord Ansuan.
Madam Chair, the body of the complaint does not contain any express provision in the ICI's charter that limits investigations only to political opponents, nor does it contain any instances of limiting of any instances or policy or rule exempting allies. In fact, I remember that even the President's son was summoned to the ICI. Nor does the complaint state any rule by the ICI which bars or obstructs any investigation against allies. And I have seen several instances in which supposed allies of the President were summoned to the ICI. To emphasize, the President has the authority to create ad hoc investigative bodies to ensure faithful execution of our laws. And saying so, the ICI is only a recommendatory and fact-finding body. Furthermore, allegations of political targeting are only speculative, and bad faith cannot be presumed. They must be proven with particularity.
The Honorable Garbin.
Thank you, Madam Chair. The establishment of such body like the ICI falls within the President's executive and administrative discretion, which we have constantly regarded as political question and which is outside the ambit of this honorable body. Be that as it may, the complaint likewise does not allege ultimate facts showing abuse, unlawful purpose, or concrete acts of favoritism directly attributable to the President. Absent specific evidence demonstrating selective enforcement or deliberate shielding of particular individuals through identifiable presidential acts, the allegations, Madam Chair, remains conclusory and cannot sustain a finding of an impeachable offense.
Thank you. Any other member?
Madam Chair,
The Honorable Abante.
if I would like to give my own manifestation on this.
Is this on the fifth
Hindi-
offense?
Ano po yun?
Is that on the fifth offense?
Yes, yes.
You may proceed, Honorable Abante.
Although the ICI should have been given more powers to investigate and to subpoena na hindi po nangyari. Ito pong si Attorney Andre De Jesus. Hindi ko alam kung anong klaseng abogado ito. Pero nakakahiya naman doon sa members ng ICI na magaling mag-imbestiga at para bang sila din po ay nagkasala din at nagkamali rin sa taong bayan. I just would like to say na walang kwenta po itong sinasabing itong tinatawag natin na respondent created the ICI to shield corrupt allies. Siguro po, kung siya ang presidente, gagawin niya yun. But the thing is this, no, ha? Palagay ko talagang wala na pong sufficient grounds tong impeachment na ito, eh. Dapat talaga ibasura na ho natin ito sa lalong madaling panahon. Maraming salamat po, Madam Chair.
Madam Chair. Madam Chair.
Honorable Abante, let us be cordial to our complainants.
Madam Chair.
Nonetheless, we recognize the Honorable Erice.
Madam Chair, nakakaasar na rin po kasi.
All your manifestations are noted.
Madam Chair, I would say that the ICI is a complete failure. As evidenced by the resignations of the two members of the ICI. Pero hindi po nakakahulugan ito na ang Pangulo ay ginawa ito para pagtakpan yung kanyang mga allies. Ito po ay isang speculation at isang conclusion rather than a fact. So, Madam Chair, I don't think that this is a sufficient basis to impeach a president. Thank you.
Thank you, Honorable Orice. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. I think we had lengthily discussed the 5 grounds of the De Jesus
Correct.
impeachment complaint. And if we are ready, let us now vote on this.
You would like to vote already?
Yes. Unless
We
will have
acknowledge
it
the
tomorrow.
contribution of all the members
Okay.
for having this exhaustive and lengthy discussion on whether or not the recital of facts actually constitute an offense determinative of the jurisdiction of the Justice Committee, no? We've heard significant discussions on the needed ultimate facts, that there must be specific details for us to be able to substantiate the offense which constitute the ground for impeachment. We've heard also discussion about the need for authenticity of not only the records but even the video. We've heard also about the need for personal knowledge with respect to the allegations of the facts in the impeachment complaint, as well as the nexus, which was repeatedly mentioned by the Honorable De Lima. It's not enough that the impeachable offense is, or the impeachable official is guilty of an offense. That offense must constitute a ground for impeachment, no? I hope that all our significant discussions will be used by the honorable members of the committee when we vote on whether or not the impeachment complaint of De Jesus is sufficient in substance. In that regard, I wish to share to the committee that the chair is in receipt of request to do the voting on the sufficiency in substance of De Jesus' complaint on our succeeding meeting, that is tomorrow. The reason is to give time to the members of the committee to ponder, decipher, evaluate all the comments and opinions we've heard today. So, if all the members are amenable to that, contrary to what we did yesterday, we concluded our deliberation already about the sufficiency in substance of the Jesus complaint, but we will be voting on this tomorrow afternoon after we are done with our deliberation on the sufficiency of substance of the Masa et al. Complaint. We wish to seek also the understanding of the endorsers and even the complainants in Masa et al. Complaint. Medyo naging exhaustive po ang ating discussion, and we want to give time to the members of the committee to recharge, to have a fresh mind when they listen to the manifestation of position of the endorsers of the Masa et al. Complaint. So, on that point, if the endorsers and the complainants as well as the members are all amenable, we will be listening to the manifestation of position on sufficiency and substance of Masa et al. Complaint tomorrow, that is Wednesday, and we will be voting on the sufficiency in substance of both the De Jesus complaint and the Masa et al. Complaint tomorrow as well. Do all the members agree to that? If so, if there are no other matters you would like to discuss in today's hearing, then the chair is suspending our today's hearing until tomorrow, February 4, 2026, 10 o'clock in the morning. The members present today are considered informed in today's hearing. Our hearing is suspended.